For the position in India, one of the most landmark cases is R.G. Anand versus Deluxe Films and others. It's a 1978 Supreme Court decision. The court held, where the same idea is being developed in a different manner, similarities are bound to occur. In such a case, the courts should determine whether or not the similarities are on fundamental or substantial aspects of the mode of expression adopted in the copyrighted work. If the defendant's work is nothing but a literal imitation of the copyrighted work with some variations here and there, it would amount to violation of the copyright. In order to be actionable, the copy must be a substantial and material one. The court also went on to say that one of the surest and the safest tests to determine whether or not there has been a violation of copyright is to see if the reader, spectator or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original. Now, in another case, another landmark decision, it is a 2008 Supreme Court decision, Eastern Book Company and others versus D.B. Modak and another, where the touchstone of law relied on by the court was, first point, section 5214Q excludes the reproduction or publication of any judgment or order of a court, tribunal or other judicial authority from copyright unless the court, tribunal or any other judicial authority makes it copyrightable. Second point, the Copyright Act is not concerned with the originality or literary merit. Third point, a copyrightable derivative work should be original in the sense that by virtue of selection, coordination or arrangement of pre-existing data contained in the original work, the new derivative work is somewhat different in character. Fourth, to secure a copyright in the judgments delivered by the court, it is not sufficient to show that the author has produced the material with merely labor and capital. Fifth, derivative work produced by the author must have some distinguishable features and adds flavor to raw text of the judgments delivered by the court. Now, I would like to conclude. So, originality is important in understanding copyrightability of a work in question, and the tests for determining originality have evolved over time to form the present standard of test as laid down in Feist Publications or CCH Canadian Limited or Eastern Book Company case. The stance of the courts in most jurisdictions seem to be quite liberal. They acknowledge copyright of a minimal amount of originality if a minimal amount of originality is shown, which happens in most of the cases, but they rightly filter out the minuscule amount of cases where even the minimal amount of creativity is missing. The present regime bars such mechanical copying work from entering the copyright regime. The importance of originality and its present position in the copyright regime point towards the encouragement and promotion of intellectual property, one originating anew from the human intellect, and discouragement of free riding on someone else's intellectual property. Thank you.